couple of PSAs before we launch into this hearing review. If the mere mention of Turtleboy, dun dun dun, makes you seethe, then I suggest the Karen Read trial is not for you. And before anyone points fingers at Turtleboy, dun dun dun, for making this trial about himself, that's not how it happened at all. It's true, Turtleboy, dun dun dun, was one of the first people to cover the story, and inarguably brought attention to it. But back then, at the start, he was just a journalist, bringing us the facts. The second PSA is for those who can't handle listening to ADA Adam Lally. But unfortunately for us, that's who brought Turtleboy, dun dun dun, into Karen Read's case. Not as a journalist, but as a co-conspirator. So let's step back in time and listen to a couple of minutes of, dare I say it, Adam Lally making misrepresentations to the court in an attempt to get Karen Read's bond revoked.
The statement, as the district attorney indicated in it, was in response to an extraordinary degree of relentless and really relentless harassment and intimidation of nearly every witness associated with this case, which included a July 22nd rolling rally of nearly 100 people traveling to witnesses' homes and calling them murderers. As the court is well aware, there is a significant history between this defendant, Mr. Yannetti, Mr. Jackson, and the social media blogger, Mr. Kearney, who's now been indicted for intimidation of witnesses in this case. And with reference to that, there is a significant, despite public indications to the contrary, that indications from Mr. Kearney's phone, which was seized, is that there is a precipitous amount of phone communications, indications of communications between Mr. Kearney and Ms. Read on a signal messaging app, an encrypted app, as well as, I believe, about 189 phone calls over a span of a few months. And that's just what's indicated or contained in the phone. There is also, going back to the spring of 23, direct communications between Mr. Kearney and Mr. Yannetti and Mr. Kearney and Mr. Jackson. They went out to lunch with Mr. Kearney following a court date in May of 2023. And this is a person who counsel in the memo seems to want to distance themselves from, based, I'm presuming, on subsequent indictments. But the truth is in the phone. The phone doesn't lie. The data don't lie, people do. As far as those communications are concerned, as far as those communications between counsel and between the defendant in this particular case. So to say that this is a different case, again, I would suggest is a large minimization of what actually has transpired here.
You weren't expecting that, were you? My intro music and lyrics actually came from Adam Lally himself. Anyway, this 300-page document that Adam Lally is summarising here ends up being D.A. Morrissey's excuse for what attorney Melanie Little refers to as the hostage video. And Yannetti's response to D.A. Morrissey's press release is where this song came from.
District attorney went off the rails. Innocent until proven guilty. Never came out of his mouth. That is outrageous. We are outraged.
But let's not get sidetracked. The point is, this whole harebrained scheme to bring Turtleboy, dun dun dun, into Karen Read's case as some kind of nexus to criminal conduct by the defence team was cooked up by D.A. Morrissey and the third-party suspects. If you need a refresher on how that all came about, there's a link in the description below to catch you up to speed. Anyway, during the final pre-trial hearing, before Trial 1.0, both the defence and the prosecution agreed to exclude any mention of Aidan Kearney from the courtroom. Now, in any normal case, when both parties agree to something, it doesn't need to be brought forward in a motion, but that's not the case here. So here's a quick recap of what happened with that.
You were both in agreement on what's the defendant's motion to exclude irrelevant and prejudicial evidence regarding alleged harassment and/or intimidation of a witness, and the Commonwealth's for different grounds and different scope, actually. Motion to exclude mention of Aiden Kearney, a.k.a.
Turtleboy, Turtleboy, Turtleboy. Dun, dun, dun.
And his pending criminal charges for witness intimidation. So, though you both agree it's out, that doesn't necessarily mean that I agree with you that it should be out. I understand that the nature of the harassment, mindful of the grand jury minutes that I've read, that in response to some of the questions posed by those at the U.S. Attorney's Office, the answers explained away some conduct as a result of the extraordinary harassment witnesses were undergoing. So I'm not sure I agree with you.
As far as I understand it, the grand jury that she's referring to here is the one that didn't see a ham sandwich when presented with the witness intimidation against Karen Reed. So the fact that she wants to use it in this trial, when Karen Reed was never indicted for it, is textbook prejudice. So how did she rule on this motion? In the exact way that we come to expect from Aunty Bev.
So go ahead and try and persuade me, but what I'm inclined to do is keep it out in the case in chief, but Commonwealth said you told your witnesses not to discuss it. So I'll hear the defendant.
I guess I would start, Your Honor, by saying that do you intend to follow up with questions?
I'm not questioning the jury. It's clear that it may be a response, a natural response by a witness that neither one of you intended to get as a reason for something, right, that I'm not going to sanction the witness because I allowed the Commonwealth's motion.
Sure. So,
Mr. Yannetti, yes. So it's clearly you try your case the way you want to try your case, and the Commonwealth decides how they want to do it. But I am not tying the hands of witnesses to natural responses to questions. So I'm taking this under advisement. If you open the door, it comes in.
Well, I completely understand that, Your Honor. I will say that I think probably, I don't want to speak for Mr. Lally, but I think...
So don't speak for Mr. Lally. I'll hear from him in a minute.
I'll speak for myself then, if the court will allow me.
So I think we're all on the same page. Neither of you intends to introduce this in your cases, but if you open the door, or if it's a natural response from a witness, it comes in.
And just like that, she signaled to Lally that she had left the door ajar for him to kick it open. And what did Lally do? He didn't just kick it open, he took it off its freaking hinges. We'll come back to that in a minute, because just before Lally kicked the door off its hinges, Aunty Bev unceremoniously ejected Turtleboy, 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 dun dun dun, from the courtroom. Here's that scene.
Good morning, Your Honor. Timothy Bradel on behalf of non-party Aiden Kearney, who for the record is present in the courtroom.
So I do want to say a question before we begin. Commonwealth, in your motion to exclude an individual charged with witness intimidation in connection with this case from the courtroom during the testimony of certain witnesses, before we begin, are you advancing the concerns of the DA's office or the concerns of the witnesses themselves, or both?
Both, Your Honor.
Okay, so...
Judge, if I may, I'm sorry to jump in, but just if I may, I do have what I think is a pretty substantial procedural objection.
Okay.
Maybe I'd ask that you sort of just make a quick bifurcation of the issues here, and we can address the procedural issue before we get into the substance of the motion.
Sure, I'll hear you.
We could. Thank you very much, Your Honor. Your Honor, so the record is clear, because we may need an appellate record in this case.
Okay.
But I was here in the Norfolk Superior Court today, completely unrelated to Mr. Kearney, my client, as you know, in the other matters. But I was fully focused on that matter and had no notice whatsoever that the Commonwealth was in the Reed matter, was seeking to exclude my client as a journalist from this courtroom. And I asked that the ruling be that it be denied on procedural grounds. The procedural grounds are, Judge, that there's been no service of process whatsoever on a case where the government is seeking to essentially trample all over my client's First Amendment rights as a journalist on 15 minutes notice. I'm trying to address it as best I can, but I think that the procedural issues here should control. And here's the procedural situation, Your Honor, that the government filed this 6-page motion. There's a footnote 2 that refers to them serving this motion on May 8th to the Associated Press. Why they couldn't just pull up my email and serve me is an open question. So there's some funny business going on here, and there's been nothing but funny business from where I sit from the Commonwealth on Mr. Kearney's matters. And here we go again, number 1. Number 2, Your Honor, Mr. Kearney has covered this case and written about 350 news articles on this case. He has developed evidentiary scoops on this case that have added to the quantum of evidence in the matter.
Herein lies the problem. His investigative journalism turned up evidence that the police didn't look for. Not only did they not look for it, they didn't welcome it either.
This is more personalized retaliation from the Norfolk County DA's office against Mr. Kearney. Another point, Your Honor, is that this matter, as far as the Commonwealth is concerned, is res judicata times 2. Judge Krupp in this very court addressed this exact issue about Mr. Kearney covering this matter, being in the courtroom with witnesses that had a stay-away order. All the same people that the government is trying to have another bite at the apple with here. All these people, this was adjudicated fully with the Special Assistant DA before Judge Krupp, and Judge Krupp ruled against the Commonwealth.
Okay.
So this is done. This has been adjudicated. It's been adjudicated again, Your Honor, by Judge Pomeroy across the street in the district court. One of these people associated with Mr. Kearney's detractors, Ms. Gattani, has taken up with the Commonwealth and sought charges and sought a restraining order against my client. And Judge Pomeroy recently, as recently, I think it was a couple of weeks ago, we were across the street, Your Honor, seeking to vacate the order under the doctrine of unclean hands. The ruling in that matter, Judge, was another ruling in support of Mr. Kearney's First Amendment rights. It was another ruling that said Mr. Kearney was not subject to the restraining order in any court of the Commonwealth. And the reason we brought that motion, Your Honor, was because these same witnesses that the government here is, again, trying to advocate for their own personal issues, those same witnesses somehow took up with this plaintiff across the street, Ms. Gattani, brought her to court here in prior Reed proceedings to kick out Mr. Kearney. And that situation was what we addressed across the street with Judge Pomeroy. He agreed with us and said, you can go to court, you can cover this case. So number 2, litigation number 2, this has been established. So thank you for hearing me, Your Honor.
All right, sure. So, Mr. Bradel, I agree with you that Mr. Kearney is certified by the Office of Public Information pursuant to SJC Rule 119, and that he has a right to be here today. He arrived timely, and that he is registered. I have honored that 119 registration today, and I will continue to honor that. However, my role in this case, Commonwealth versus Karen Reed, is to assure that the defendant's constitutional right to a fair trial are honored and upheld. And because of the chilling effect that Mr. Kearney's presence, I find, will have on the witness's testimony, I'm going to excuse him while the named witnesses in the Commonwealth's motion, Julie Nagel, Christopher Albert, Colin Albert, Michael Proctor, Jennifer McCabe, Matthew McCabe, Brian Albert, and Yuri Buchanek. And the Commonwealth also today requested Nicole Albert.
Your Honor, one last thing, if I may, just came to me as I was standing here. Extension in same regard as to Nicole Albert for the address would be Brian Albert Jr., son of Brian and Nicole Albert, lives at the same address.
It's for the same reason, so Brian Albert Jr.
So there you have it from the horses' mouths. It is D.A. Morrissey who keeps dragging Turtleboy, 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 dun dun dun, into it. He's just as happy to be a journalist, just like everybody else sitting up there on that bench where all the journalists are. And before anyone says, oh, but he goes up and puts a camera in people's faces and asks uncomfortable questions, let me remind you.
Trooper Proctor, Kathy Curran from NBC 10. We'd like to ask you some questions. Do you think your actions impacted the outcome of the trial?
Get off of our lawn. Right?
I'm not on your lawn, I'm on the street.
That's what journalists do. But notice, NBC 10 hasn't been dragged into multiple courts for witness intimidation or even trespassing, since the proctors seem to think that the public roadway is part of their property. Anyway, moving forward in time, shortly after Aunty Bev ejected Kearney from the courtroom, Alison McCabe testified. And this is where Lally took the door off its hinges the first time.
I had asked you if, prior to getting rid of your old phone and getting the new one, if law enforcement ever asked you to, go through the phone themselves, and you had said no, right?
Yes, they did not do that.
And they never asked to do an extraction on the old phone, correct?
No.
What about the new phone that you now have, that you got in December? Have the state police ever asked to do, have they ever asked to look through that phone?
They look, no, I don't think so.
You provided the screenshot that was shown to the jury today on August 25th when you talked to the state police in this case, right, of 2023?
Correct.
And when you provided them that screenshot, did they say, hey, by the way, can I look at your phone to see if it's on there?
Objection.
I'll allow that. Did they say that to you?
I don't remember.
But in any case, you never physically showed them your phone, right?
No.
You don't recall clicking on that text message app, the green app with the kind of white speech bubble. You didn't click on that and then click on the Colin Albert conversation and say, here it is, did you?
No.
And in addition to not asking you to see your new phone, they also did not ask you to do an extraction of your new phone, correct?
Correct.
And at some point in time, you realized that you'd have to be a witness in this case and have the unfortunate incident of having to talk to me, right?
Objection.
I'm going to see Counsel at sidebar for just a minute on this.
And so, it was this line of questioning that Lally thought eliciting this type of a response was appropriate.
What, if any, harassment was there in relation to that and in relation to Colin?
Well,
No, go ahead, she can answer.
Colin wasn't at the house, so he's being harassed he was not at the house when John was there, so I drove him home. So the people are harassing him saying he was at the house when it's not true.
When you speak about harassment, what specifically type of harassment are we
Constant phone calls, emails, awful messages.
Objection.
I'll allow it. Focus on this witness, not Colin Albert at this point.
As far as you and your family, what, if any, type of harassment have you received?
People showing up at our house, people emailing my school, just like a lot of harassment. Can I have a moment, please?
Sure.
Ali McCabe claimed that the defence brought up Colin being in the house. The defence did not. The defence was questioning her about the forensics of her phone data. Aunty Bev claims the defence opened the door, but at the end of the day, all this was just a fancy little PR stunt to make the McCabes and the Alberts appear as victims, not perpetrators, i.e. textbook prejudice. The problem is, the public protest didn't happen until a year after Officer O'Keefe was found on Albert's front lawn. So the protests literally have nothing to do with why Ally McCabe didn't hand her data over more than a year earlier. The bottom line is, DA Morrissey and also now Chief Rafferty have both given impassioned speeches condemning protesters and painting third-party suspects as victims, i.e. textbook prejudice. Moving right along, DA Morrissey's boner for dragging Turtleboy, dun dun dun, into this case was further exposed by attorney Mark Betterow, who joined Kearney's legal team and in the process of discovery found Morrissey communicating with members of the McCabe and Albert families using a burner email account to influence judicial rulings in Kearney's case. This all brings us to March 20, when Judge Sisitsky ruled the Commonwealth could subpoena only communications between Karen Read and Aidan Kearney under Rule 17, and only those related to 3 specific allegations: consciousness of guilt, coordination with the defense, and witness intimidation, which gave us the infamous Dream Team bursting in on Brennan's secret Rule 17 motion. In yet another DA Morrissey attempt to drag Aidan Kearney into Karen Read's case. Now, you could be forgiven for thinking that DA Morrissey's boner for Turtleboy, dun dun dun, just got a whole lot more, well, bonier, due to Mark Betterow exposing him. There's nothing criminal about writing a letter to the prosecution on behalf of your client to let them know that you want more discovery. This is generally how lawyers come to agreements on what they're going to do and share without filing motion after motion after motion to the court. Nor was there anything unethical about transparency. At that point in time, that discovery was not under seal. But that didn't stop Morrissey's office from publicly defaming Mark Betterow in order to keep him from joining Karen Read's team. I think that effectively brings us up to date for part 2, where I ask the very simple question, is Judge Sisitsky a hero or a villain in this story? Because, as Aidan pointed out, none of us even understand why Brennan's Rule 17 motion is being called in Canoni's courtroom under Karen's docket. Aidan's hearings have always been at Stoughton. He doesn't live in Dedham, he lives in Worcester. So stay tuned while we bring this confusion to the forefront and try to iron some of it out. Part 2 is up next.